Hello. Um, Good afternoon if you're in the UK or Europe. Good morning in California. Good various other parts of the day and evening in other parts of the world. We're very, very happy today to welcome Professor Daniel Lee of the University of California, Berkeley, political science professor there. And we're going to talk this time about Roman private law and the roots therein of later conceptions of public and international law. So, Dan, we had some technical difficulties setting up the meeting. And so, just to be sure that everyone is able to hear, see, and speak, Dan, can you hear me correctly and see me as well?
I can hear you just fine. Good morning. Good evening, Bill.
Excellent. Thanks, Dan. Great. So we can see and hear each other. That's very good. Hopefully the attendees can also see and hear us. And so what I'll do now is turn the floor over to you, Dan. You can talk for basically as long as you like, about whatever you like, to get us started. And then after that, we'll have some questions and discussion, and then we'll open it up to questions from the audience. For those people in the audience, there is a tab. It probably will be at the top of your screen on this Teams software, which is a little bit different from Zoom. At the top of the screen, there should be a Q&A tab. Please click that and put your questions there, and then I will pose them during the question time to Dan. So at any time, feel free to click that and write your question there, and we can get it posed later. So without further holdups, take it away.
Great. Well, first of all, Bill, thank you so much for inviting me and for suggesting this discussion here. As I understand it, the bill for this series is Ancient Geopolitics and the influence of the ancient world on modern thinking about international relations and geopolitics. And there's a lot that I wanted to talk about this because there are two centers of gravity in the work that I've been doing. One part of it is the history and the theory of sovereignty, the legal aspects, and all the problems that are associated with the legacy of sovereignty. So I'll talk a little bit about that. And then the other center of gravity is the legal history that provides the construction of sovereignty as it's understood today. And that is, as you mentioned in your introduction, Roman private law. So I'll talk a little bit about how I arrived at this general area of research, why it continues to motivate a lot of the material that I study, and some of the potential directions that I'd like to move in some of my current work. First of all, it's nice to see you, Bill. For those of you who don't know, Bill and I used to be colleagues when we were teaching together at the University of Toronto. And I think we were office mates for a brief time too, weren't we?
Yes, yeah. And we used to commute together between the different campuses and all kinds of things. Yeah.
So it's really nice to have this chance to reconnect. And, thank you for, even though we're thousands of miles apart, it's really nice to have this chance to reconnect this way. Let's start a little bit with a few words about sovereignty. Why is sovereignty still important? And I think when I first arrived at this topic, when I was in graduate school, that was the time when it was fashionable to say that sovereignty was on its way out. Sovereignty was eroding. This was the post-Cold War era. Sovereignty is no longer important. There's going to be much more international cooperation, and the sovereign state is on its way out. And I think what events and the experience of the past maybe 2 decades have proven to us is that that's certainly not the case. Sovereignty is here to stay, and it remains the central building block of the modern international order. So I think it's important to understand, in reimagining sovereignty, not to wishfully think about a world without sovereignty, but to imagine how sovereignty could be reimagined and what that future might look like, that includes a world in which sovereignty plays a vital role, but not to think about a world where sovereignty automatically is erased out of the picture. So that motivated a lot of my thinking about what sovereignty was, and what makes sovereignty distinctive. And I think part of the difficulty in modern social science is that it seems to me that people have approached the topic of sovereignty from several different angles. There are those who think that sovereignty, particularly those, many of my colleagues who specialize in international relations, tend to think about sovereignty as just as a concept in realist politics as simply brute force, right? Whoever has the most guns, whoever has the most tanks, whoever has the most bombs, that's what sovereignty is. It's sort of like the power of the gunman. Whoever has the gun, whoever has the power to coerce, that's another way of thinking about sovereignty. So that's one way of thinking about it. But I think there's been a situation where I think social scientists are talking past each other, because there's another point of view which sees sovereignty as constructed of norms. And you might think about sovereignty as the one who controls norms, the one who gets to say what the rules are. And so you might think of it as a concept of authority, which is, I think, is the traditional way that sovereignty has been described or defined as the supreme or the highest authority within territory, within a state. The other thing that I just want to briefly mention at the outset is that I think we're accustomed to thinking about sovereignty as a territorial concept, defined principally by borders. And when you come upon the border, I mean, I think during the Cold War era, right, the Berlin Wall was the most visible, artifact of what sovereignty was supposed to be. And we see it today, even in border politics, that continues. But what I've discovered in a lot of my research is that the further back in time you go, sovereignty is not so much a territorial concept as it is a relational concept. And I want to talk a little bit more about that as I look back at some of the earlier sources that I've worked on. So those were some of the initial motivations for thinking about sovereignty. And what are the sources of this idea? How did this idea, how was it motivated? My background is in political theory. And one of the things that political theorists are trained to think about is what made it necessary in the world to invent this concept in the first place. Right? There must have been a time when sovereignty was not part of the political vocabulary, and so at some point somebody had to invent this concept, or there had to be some discourse that made it welcoming. And so, at what point did that happen? And there's several different explanations for when that occurred, but probably the standard explanation is that it really occurs beginning in the 16th century, which is the period of the Reformation, the period when the modern nation state starts taking a more recognizable form. But within the period and within the context of intellectual history, you begin seeing treatises, formal treatises and texts that start asking the question, what is this thing called sovereignty? And probably the most important work along those lines is a work that's published in 1576 in French for the first time by a political theorist and a lawyer named Jean Bodin, who's universally recognized as probably the first architect of the modern theory of sovereignty. I'll return back to him a bit later on, but one of the things I discovered in looking at Bodin is the many sources that he uses in order to reimagine or I wouldn't even say reimagine, but to reimagine in the first place, what would a world organized along this recognized norm of sovereignty might produce? How might politics be conducted? What would war look like? What would economy look like? And one of the many things that's interesting for me in studying Bodin is that the way he reimagines international relations, the constitution of states, the nature of authority, is that he looks backwards. And so many of his inspirations comes from the ancient world, and probably most importantly, the experience of the Roman Empire. Many of his sources come from Roman law, which is not surprising because Bodin himself was formerly trained as a Roman lawyer, or in Roman law, which is the standard curriculum for professional lawyers, which still is true in many respects throughout civil law jurisdictions in the world. But certainly in the 16th century, the continuing influence of Roman law could be felt even within the way that Bodin studied and constructed this concept of sovereignty. So that brought me back to the ancient world. And the main source that I spent a lot of time studying, and in some of the earlier works that I had written, and continues to shape a lot of my research, is Roman private law. And I think maybe, Bill, I think you said maybe we could start with that. Is that what you'd like to do?
Sure, that would be great. I think I like the introduction so far, and I think it's a really good point as well, although our colleagues in IR might be a little bit perturbed to say that there's a lot of space between kind of John Lennon, imagine there's no countries, and Carl Schmitt, the sovereign decides the exception, right? We're somewhere in between that space when we think about sovereignty, yet sovereignty still is quite important. I also like where this is going so far. So yeah, I think in terms of private law and how that feeds into sort of Bodin taking that out of private law to a kind of public law domain, it may be worth actually first elucidating for the audience who may not all be law focused. What's the difference between private and public law as concepts? Because that may not be obvious to non-lawyers if they're in the audience.
Yeah, well, I'm a non-lawyer myself.
Me too. I'm not a lawyer either.
Yeah, I look at many of these legal questions from the point of view of an outsider, but it's really fascinating seeing how legal practice and legal culture shapes how politics is experienced and practiced in other contexts. But I guess the short answer to your question is simply to say public law is the law that establishes and governs the rules of public institutions, governing institutions, and private law is the law that governs relations between private individuals, citizens. So think in terms of contracts, delicts, or the equivalent in English common law would be something like torts, as well as the law of persons, family law, these sorts of things. So when we talk about Roman law, we're mostly talking about the legacy of Roman private law. So what did the Romans have to say about the law of persons? Rome was a slaveholding society, so what did they have to say about slavery? Commercial transactions, contracts, the sort of contracts one could enter into, the law of marriage, the law governing orphaned children and what happens to estates. And so there's a whole law of guardianship that addresses those sorts of situations. I mean, just to kind of organize all of this, there was a famous lawyer named Gaius who wrote one of the first treatises on Roman law, a textbook that was simply called the Institutes. And it was rediscovered in the 19th century and then published and studied over the past 2 centuries or so. And there's a famous sentence that Gaius presents to his readers, which says that all Roman law consists of persons, things, and actions. And I always found that to be a very useful way of organizing, a lot of my lectures when I teach undergraduates, the substance of classical law, because it deals, first of all, the different legal categories that Roman lawyers classify people into. And so that's one of the major areas of Roman law. Things, which is not a good translation of the Latin word res, but what it really means is assets, anything that has monetary value. And so there are 2 ways of thinking about that. Property, what you own, certainly has value. So those could be assets. And so the law of property, of course, you might expect to be a part of Roman law. But also not just what you own, but what is owed to you. So think about debts. When you enter into a contract, you're creating something like a credit debt relation. And so if somebody owes you something of value, that's something that you can also add up. Say if you're writing a balance sheet or something like that, an accounting of all of your assets. If people owe you money, that would be considered a thing or anything of value that would also be classified under that rubric. And so, as well as other types of obligations, so when, for example, there are injuries or damages of some kind, when there's theft or somebody impugns your good name, all of these would be things or assets that could be accumulated and that you could write up as things that are owed to you. So all of this falls under the category of the second category that Gaius identifies. And then there's the third category of actions, which really is lawsuits, legal remedies. Law doesn't mean anything unless you can sue for them. So, and I often tell my students this is the most important aspect of Roman law, because it's one thing just to study what the principles of law or what the rules are, but the rules don't matter unless if they can give you something of value in return. And so I usually tell my law students and students who study Roman law that studying Roman law is sort of like going to Hogwarts. When you go to Hogwarts, you're studying magic spells, right? You're trying to cast spells, but you have to use the right words, right? You have to use the right spells in order for the spells to be effective. I say the same thing about lawyers, right? You have to learn the proper legal spells in order to get the effect, or in order to get the conclusion or the result that you want from a court. Otherwise, a judge is not going to act in your favor. So there's a long way of simply answering your question, what is private law all about? Those are the main different elements that you'll find. And there are many textbooks that still do this, including, Roman law is still a regular course that's part of the law curriculum at your university. And so royal professors since the 16th century, that's a member of your faculty, and will generally follow this same curriculum for the most part, that will look at persons, property, obligations, contracts, delicts, and then actions. Just one other detail I just wanted to say before we leave this topic. You asked about public law, and usually in public law, today, if you're a law student or a legal scholar, there's a whole area of public law that deals with constitutional structure, constitutional law, public international law, these sorts of topics. The Romans thought about it somewhat differently. They also included aspects of the structure of their state, the structure of the Roman Republic, sources of law, all these sorts of issues are important parts of it. They also included aspects of religious law, because religion was an important public function of the Roman state in a way that kind of dissolves by the time you get to the modern world, and especially today, when there are established norms about the separation of the church and state and these sorts of rules. So when you look at a lot of Roman public law, it's not directly about, at least in a recognizable sense, about politics or political functions of state, but I just wanted to throw that out there. Mm-hmm. The only other final detail is that public law is regarded, the Romans called it mos maiorum, which meant that these were customary, they weren't written down. And as a result, law has to be reconstructed. And there was a very famous German scholar of law named Mommsen, wrote a very famous text called Römisches Staatsrecht, or Roman public law, that tried to use all the different historical sources to reconstruct Roman law. So anyway, that's the basic difference here. I suppose I could talk a little bit about why, what am I taking out of sovereignty here from Roman law? Maybe is that maybe one thing?
Yes, I mean, I think the introduction to sort of Roman concepts of law from Gaius is really good. Maybe we could help unpack a little bit more sort of what was the defining aspect of Roman private law that was attractive maybe to later scholars. So if I think about private law, I always think about kind of tripartite dispute resolution as being a hallmark of it, versus public law, which could also even be criminal law, where at least one party involved in this is the state or a public institution of some sort, right? But did the Romans have a real concept of tripartite resolution, or were they sort of constructing private law in broader or looser terms, or very specific terms that were somewhat different from the way we might think of private law today?
Yes, they certainly did. I would say there may be 3 or 4 different ways in which Roman law and the legacy of Roman law directly shapes how early modern theorists reimagine the state in territorial and in relational terms in the way that I described earlier. So one important thing that I would just simply mention is that Roman lawyers, all of these treatises have asked the question, we have all of these Roman laws that are just kind of floating around, we have to reorganize them. Where did these laws come from? Who organizes, who authorizes them in the first place? So at the very beginning, they have to answer that question. And what you'll notice in all of these is that, first of all, the plurality of sources of law. There's no single legislative process within the Roman Republic and then later in the Roman Empire. There are many different sources, so they have to give some sort of explanation about, does it come from the Senate? Does it come from the popular assemblies? Is it sourced from plebiscites or from plebiscitary decrees? One of the important notes that the Roman lawyers add is that when Rome decides to become an empire that is under the sole rulership of one emperor, they have to recognize that the will of the emperor has the force of law. There's a very famous passage within Roman law that becomes notorious later on, which says, quod principi placuit legis vigorum habet, which means in English, what pleases the prince or the emperor has the force of law. Now you can see why this becomes notorious, because later power-hungry monarchs are going to use this as authorization for them to say, well, if it's good enough for the Roman emperor, why can't I, as a prince, also claim that my will has the force of law?
I am the state is me, basically.
Yeah, exactly. Yeah, and so it becomes quite popular by the time you get to some of the absolutist rulers trying to grab power, and you know, unfortunately, there's a contemporary history to that now that I think is continuous with that in some ways. But Roman lawyers wanted to say that the emperor was the source of law, and so you ask, you know, this tripartite picture, you know, what does the state do? Representatives, but the state play some role in dispute resolution when you have legal conflicts, and certainly that's the case with the emperor, who viewed himself as a kind of judge. Indeed, the emperor had sole privilege to act as sort of like the supreme judge, you know, the final court of appeal throughout the entire empire. So, of course, cases would be coming to the imperial court all the time for a final decision, and that would actually be one of the important vital sources of Roman law later on in Roman history. So one of the important features of Roman law, and this is one thing I want to mention, and I think I could show you one of the things that I wanted to, I'll talk about in a moment, is that Roman lawyers have to describe why is it that the emperor has this capacity to decide all of these aspects of law. And there's a very famous passage, again, that would also become notorious, where the Romans describe the emperor as being exempt from legal obligation. Princeps legibus solutus. Now, one thing I wanted to do is I wanted to show you some of the books in my collection. This is the Gestum Vetus, which is the first part of Justinian's Digest, which is the main collection of legal texts that Romans use. This is the one that I use and have in my collection. This is from Venice in 1569. And I just wanted to show you this passage here, if I can put it up against the screen.
Yeah.
There's a very famous passage right there. Let's see that. Okay, and it says Princeps legibus solutus est.
Yeah.
It's a famous passage. And that's actually one of the sources for the word absolute. The prince is absolute, but it comes from the source. What it really means is that it's not that the prince is absolute, but rather that the prince is exempt. And it's connected to, if you know, if some of your listeners are familiar with Catholic doctrine, you know, the power of priestly absolution, the power to release or to exempt from sin, is the same sort of idea that is captured within this text. But the source of it, you can trace it back to Roman law. But that becomes very important later on, because when you get to somebody like Bodin, he's going to be using exactly that same language, and I'll show you that connection later on. Anyway, that's one thing I wanted to mention. You asked also about, you know, what other aspects of Roman private law shape sovereignty, and the other thing I wanted to mention was slavery. Right?
Yeah.
Roman law was a slaveholding. The Roman Empire was a slaveholding society. So when those of you who may be familiar with Roman law will note that there is not a single page in the Roman Law Digest or in the Code or in the Institutes that is not somehow connected to this legacy of slavery. So when you look through these texts, you'll see slavery and the experience of slavery shaping things like the law of persons. And it shapes what type of contracts you can enter into, what type of marriage you can enter into or cannot enter into. Can you write a will? Can you engage in these sorts of acts? Now, the reason why this is important for sovereignty is that slavery is defined in terms of the master-slave relation. It's a vertical, hierarchical relation between someone who's in absolute control and someone who's in a position of absolute subjection. Now, there are ways in which that relationship is moderated. And so if say that I'm your slave, Bill, and under Roman law, you may release me from my slavery. You can, and the term for that is manumission. Exactly. You can manumit me. Literally, you can send me away from your hand. That doesn't mean I become a free person, though, because I'm marked by the stain of slavery. And so I'm still somehow bound to you. There's a bond of connection between us because of my experience to your slavery. So one of the things I have is what's called officium pietatis. I have a duty of showing piety, reverence. You might call it, in a more old-fashioned term, fealty that I owe to you, even though that I'm technically not your slave. And Roman lawyers really struggled with this. They wanted to try to figure out what is that residual bond that we have between us. Now, why is this important for for sovereignty? Because there's a similar type of relational vertical concept that modern legal craftsmen of sovereignty were trying to capture. It's not slavery, but it's something similar to that when we talk about the relation between sovereigns and their subjects. And so Roman law was very helpful for that, in trying to figure out what that connection was.
Almost if we think of political hierarchy as gradations of clientelism in a way, right? So if slavery is the ultimate clientelism, and that it's actually ownership of the client by the patron, and non-personhood essentially for the client, and then manumission is a still very strong clientelistic bond, but a little bit less, and then maybe less, and then we can have different types of client and patron relationships. And in some ways, then that seems to imply they're thinking of the state as national patron and the citizens as the body of clients. Is that somewhat accurate?
That's a very accurate way of thinking about it, but it's only one ideal type. I think what I've noticed in a lot of the early modern sources that rely on ancient law is that I think there's a greater appreciation for the diversity of types that one observes, both in the ancient world and in the modern world. I'll just say as a footnote here that when you look at these early modern sources, they're not just scholars of the ancient world, sort of like modern day anthropologists, but they're also comparative social scientists. They're looking at how did the ancient Hebrews do this? How did the ancient Greeks do this? How did the ancient Romans do this? And what they realize is that there's no single answer. So that when you come to this sort of question of, is the state something like a patron-client type of relation? It's just that exploded in terms of demographic or population size. There's no single answer. So you have, I think you said kind of gradations, which I think is exactly right. There's a very famous chapter in Bodin where he says that what we need is a taxonomy of different types of vertical relations like this. And so you will see, for example, on the one end, the harshest type of slavery that's imaginable. And he uses the Greek term for this, despotism. Despotos means the master over a slave. And on the other end, something like, the rule of law in some sense. I think when you look at Bodin, for example, he's anticipating something like the modern bureaucratic state, run entirely by rules, but where the will of the ruler is somehow minimized as much as possible. And I could talk more about that later on, but I think your point is right there, absolutely.
Yeah, let's think about this a little bit. I mean, I like the idea, first of all, of Bodin as kind of progenitor of the Rechtsstaat concept, but I think what also is interesting to me, just as a starting point, maybe to kind of segue towards that, is, Bodin is sitting in Toulouse in the 16th century, right? Thinking up these ideas. Now, why does he go back to Justinian and Roman law from Constantinople 1,000 years earlier, or more even, if he's drawing on some of these? Why doesn't he start with the Middle Ages or France in the 16th century? And why is he necessarily reaching back to the Romans specifically versus the Greeks or other traditions that maybe he had to draw on as well, or the medieval one?
Yeah, great question. I think there are two ways that I would answer this. One is that one simple answer is that he certainly does. Actually, when you look at many of the different examples that he uses, he has very much the mind of a comparative social scientist. He really cares about the different cases that he can gather together. So, he doesn't have the techniques of modern social science, but I think he has the instinct for it, where he says, if we want to figure out the different ways in which sovereignty expresses itself, we can't just look at one particular case. I can't just look at my local native country of France or some of my neighboring states. I need to gather as much as possible all the sources that are available. So he will look, for example, at the ancient world. That's one quick answer. I think, as well as medieval sources as well. So it's actually a very eclectic collection that he had. The other thing I just want to say, just a very important point about Roman law, and I'll just stress this again, is why Roman law? Why does he privilege it? And I have to give you a little bit of background just for your audience who may not be familiar, is that there's what's called a second history to Roman law, or second life of Roman law. This is what some people have usually described it. Roman law was, the kind of, this is not entirely true, but I think the usual story that's told is that the Roman Empire collapses. The work that Justinian did in collecting and collecting the Roman law that goes back to the 6th century was lost. The barbarians came in, and the Roman Empire was gone. But it's rediscovered. And I put that in quotes because it's not that it was always lost. It's just that it was not actively used as a body of law. But it was rediscovered in the 11th and 12th centuries in Italy. And that is what begins the revival of learning, where you have new universities that are beginning to emerge and pop up all over the place. And in part, this is the exercise of the church. The church wanted intellectual sources to reinforce its authority, and Roman law is a very easy way to do this. So universities they originated really as think tanks, trying to figure out how can we pull out useful material out of Roman law. And that sets in motion, is an independent intellectual tradition of universities and legal learning. The standard starting point for studying law from the 11th century onwards, certainly in continental Europe, even today, to a lesser degree, but still today, is studying Roman law. So Bodin is no exception. When he was a law student in Toulouse, he would be studying many of these texts. For example, the same text that I mentioned before. He would be familiar with all of that, as well as the accumulated body of commentaries and glosses. So that's the answer to your question. Let me just say a little bit about what happens in Toulouse, though.
Please do.
Bodin was, when he was in Toulouse, he was in university. He wanted to become, I think he wanted to become a legal academic. And, I'm actually writing a book right now, a short book on a text that Bodin had written, which was an attempt at, making the study of material like this much more accessible. So it was supposed to be, he called it the division of the whole law, so that he claimed that he could do it in a very short volume. And Bodin was not unique in this respect. Many people thought that they could do this in the Renaissance. This is part of the style of Renaissance style technical learning in this period for a technical subject like this. But Bodin wanted to become a legal academic, and he ultimately failed in that achievement. And he ended up becoming a practitioner in the Parlement of Paris, which is something like the Supreme Court of Ancient Regime France. And so that's where he got a lot of his legal practice and his legal experience. Eventually, he would make his way into the royal court in a number of various positions. But this is a very tumultuous, very volatile time in French history, because this is also the period of the French wars of religion. People were killing each other out on the streets for religious differences. Catholics versus Huguenots. 1572 was the major year, because that was the year of the massacre of St. Bartholomew, which was, I usually tell my students that it's something like the 9/11 of the 16th century. It was, everybody knew about it. It was the sort of event that would completely change and transform the trajectory of European Western Christian politics from that moment onwards. And it's one of the reasons why Catholics at that moment acquired the reputation of being this bloodthirsty, power-hungry group of people. Now, Bodin enters into the picture. Actually, he's very, very explicit in saying, I don't want to take sides in this. I think he was worried that what he was witnessing was the unraveling of the French state. France potentially becoming a Catholic France and a Protestant France. And maybe even worse than that. I think the entire history of France being unraveled within a single generation. So he took the position that was sometimes called the politique position, which is that let's not take confessional sides in determining public policy or the identity of the state, but what we need is a clear statement on what constitutes statehood. And that was in many ways one of the motivations for writing this book, De Republica. This is the 1591 Latin edition of Bodin's major text. I'll just show you this cover page here.
That's great.
Yeah. Bodin was still alive when he wrote this book. And it was this, you can see it's a fairly lengthy text. It was here that he wrote his major statement on what sovereignty is, and also importantly, what sovereignty is not. But you can see actually many of the ways in which he captures the legacy of Roman law. I'll show you one passage where he does that. And this is one page here, a very important one. This version is all in Latin, but you can see actually he documents all of his sources here in the margin here. Now,
I like the way the footnotes go all the way around the edge.
Oh,
Yeah, all these marginalia, literally.
It's mind-blowing, how he documents all that. I mean, for scholars like myself, who are studying, where are they getting their sources from? It's a godsend. So you go into all these different rabbit holes. Now, that page was important for me because it's one of the places where he defines sovereignty. I think many students of Bodin usually just read maybe the first sentence of his famous chapter where Bodin famously declares that sovereignty is the absolute and perpetual power of the state, which is not very helpful because when you dive into the chapter, he gives us actually a fairly lengthy and very technical explanation of what he means by absolute power. And what you'll find is that he's actually referring back to that earlier passage that I mentioned to you before, Princeps legibus solutus. The sovereign, if it's a prince or even the people, because he acknowledges that democracies can also be sovereign states, actually very important for him. Sovereigns are exempt from the law, but the reason why they're exempt from the law is because they have to have the power of changing their laws. And that's the connection that he wants to make. Sovereignty is about unmaking, changing. The technical term that lawyers in the period used was derogation or abrogation, which is an old Ciceronian term. But they all have to have that ability to transform and change the laws. If you can't change the laws, you're not sovereign. What that means is that you're subject to your laws. And so you're not in a position of command. So that was actually a very important stance that Bodin takes. And it leads to one of his conclusions, particularly when the French politics of the period, is that the French sovereign, the king, cannot be constrained in any ways. So it's wrong to think, it's somehow contrary to the theory of sovereignty, to think that the king of France is somehow under or subject to his own laws. If you want to change it, he can. He can voluntarily subscribe to them and recognize them, but in no way is he obliged to follow them. Now, when people read that statement, I think they're worried, well, is this some sort of apology for lawless absolute rule? And he has more to say that, because in my last book on Bodin, I actually think that's not what he was trying to say. But he has a much more elastic theory about what constitutes law that, not surprisingly, has roots in the Roman law science that he had been studying. But anyway, there's much more in this text, but I'll shut up on that point for now.
Oh, that's very interesting. I also like this idea of the sovereign essentially giving up sovereignty. That concept could exist. Because if the sovereign decides, well, I will be subject to the law, even though I'm not obliged to be, by some measure, then I'm also abdicating the sovereign position, right? I mean, then I'm no longer really the sovereign if I'm going to be subject to law.
And this is actually one of the reasons, I mean, just to go back to your earlier question, or comment that I made also, that sovereignty is not about how many guns you have. It's not about how much worse of fortune. It's a position. It's a recognized role and authority. And I can see some of the criticisms of that way of thinking, but in my view, I think there's a different trajectory in intellectual history about thinking about what constitutes sovereignty as opposed to simply, I guess if we use a Weberian language, a monopoly or violence. Usually those two coincide, but I think when Bodin is talking about it, you can separate the two because it really functions as a type of normative concept for him. Now, just to go back to your comment, though, I think that's very interesting. And I think it's very much what Bodin says. You don't have to exercise your sovereignty in order to be sovereign. Actually, one of the things he advises is that if you want to hold on to your sovereignty, one of the best things to do is don't exercise it. Let others do it for you. Right? Because you don't want to become a target. And much of what this text is about is setting up institutions, setting up courts, setting up military forces, setting up legislatures, so that even though you are the source of their authority, you don't have to be put into a position where people are going to, your subjects are going to hate you or find reasons to take vengeance on you or something like that. That's actually quite dangerous. And one of the reasons why he recognizes republics, including democracies, as being sovereign states, which is a daring move that he makes in this text. But it's also one of the reasons why republics tend to fall very easily in ways that properly constituted monarchs don't, because monarchs can always remove themselves from politics. You could have your king or your queen going off to tea parties. They remove themselves from the business of politics, which they leave to professional politicians. So they have the right of sovereignty. They don't have to exercise it. I think your point is actually very important, I think, for understanding.
So whereas the Republic would have a harder time delegating authority even to, say, court or subservient officials of some kind.
I suppose they could. He certainly acknowledges that. And actually, this might be another way we can go back to the ancient world. In this text, Bodin says he has a lot of things to say about why the Roman Republic collapsed. And what he'll usually say is that the Roman Republic begins as a law-governed state, and it was pretty good in delegating and dividing responsibilities between the popular assemblies, who, in theory, had sovereignty over this entire state. That was Bodin's position. But you had then the Senate, the high magistrates. You had the consuls, you had the praetors, you had all the other censors and the other officials. And everybody sort of knew their place and what their roles were supposed to be. Now, fast forward, and the people were just getting hungrier and hungrier. They wanted more power. They wanted to remove the Senate. They wanted to remove all of these other authorities. And so by the time you get to the last century, again, this is just Bodin, the reason why you have military strongmen like Pompey and Caesar and extraordinarily popular leaders coming into power was because they wanted to exercise more and more power rather than trusting or delegating their professional politicians to do it. For him, it was a sign that the more people try to participate and exercise their sovereignty, the less likely that state is going to survive. That's one of the lessons that he takes from the ancient world. But Rome is the tragic illustration of that point.
And that the pitfall is a kind of military dictatorship of some kind.
Oh, absolutely. Yeah.
Essentially, that you sort of have this sort of downward spiral to tyranny and military rule. In some ways, Napoleon could have read this book 200 years later after he wrote it and taken that as a kind of guidebook for how to subvert the revolution.
Absolutely. Yeah. I think there's a later history to this. One of the things I've been interested in this text is who read Bodin and lessons of this. And one thing I just want to mention right now is I do want to share this is Rousseau. So my social contract from 1762, it's a counterfeit copy because most of the original editions of the social contract were destroyed in a thunderstorm. But when you read book one, there's a famous chapter on sovereignty Rousseau read Bodin, but he doesn't cite him by name here, but you can tell that actually he's drawing it specifically from this text. It's actually a very close connection to later French thought, but this is a very good example of that.
Great. Great. So I think this is a really nice explanation of sort of how Bodin draws on specific concepts from Roman law, how the Romans themselves actually built on private law to think about the structure of the state, the relationship between the state and the emperor and society. And then Bodin draws on that to kind of build a theory of what sovereignty looks like, mostly for domestic politics, right, in terms of how the state's constituted within the country. I don't know. I thought perhaps you might also want to talk a bit about Grotius, and maybe the way that states could relate to one another in an international arena, drawing on some of these ideas, or whichever way you wanted to take it. And then I also want to make sure we open up for some questions from the audience before we run out of time. But yeah, if you do want to talk a bit about international relations or Grotius or other strands of Bodin, please.
Yeah, well, I'll do this very quickly. Just I want to be mindful of the time, but first I'll just share with you. This is my 1646 Grotius here.
It's the Belli Akpakis.
Yeah, Belli Akpakis.
There we are. Yeah.
War and Peace.
You have an amazing book collection, by the way. I have to
say.
Thank
you. Yeah,
I'm always envious of your collection of ancient books and old books.
I'll just say, partially this is out of necessity during the COVID era. You know, I couldn't access any of the rare book libraries that I needed when I was writing the Bodin book. And so I got some advice from various people who said that, you might as well just start your own collection, especially if you have, if Berkeley's going to help fund it. And so that's sort of what out of necessity I do. But I like it now because I can also use it to teach. And I think a lot of my students recognize the importance of going back to original sources and to disrupt translations. Translations don't capture really a lot of what these authors are trying to say, and actually helps me see a lot of the connections that you cannot get in modern editions. I'll just say very quickly about Grotius. So one of the important things that I noticed in thinking about sovereignty up to this point is that today it becomes common in a lot of legal literature to say that there's what's called internal sovereignty versus external sovereignty. Yeah. So the sovereignty within the boundaries of the state.
Exactly.
There's also sovereignty outside the boundaries of the state. Now, you recall earlier that I said if that only works if we're dealing with the assumption of the territorial state, where there are clear. How might that work when there are no boundaries? If we think about sovereignty as a relational concept, because you're thinking about bonds of relations that are created through something like oaths of allegiance or oaths of fealty, sort of like the master-slave or the creditor-debtor type relation. One of the things that Grotius reminds us is that sovereignty, it certainly can be territorial, but this vertical relational concept of sovereignty still remains. And when you look at some of his discussions about sovereignty, it continues a lot of the discussion that you see from Bodin, but actually in earlier sources too. I wanted to share with you one famous passage here. This is in Book 1, Chapter 3, and very famous section here. I don't know if you see that, where it says summa.
It's hard. It's a bit blurred, but yeah.
Sorry. Yeah.
No, okay. It's all right. It's not your fault. It's the technology again.
Yeah. Well, I mean, I'll just read it to you. But there's a very famous section here, Book 1, Chapter 3, Section 7, that deals with the term summa. Summa in this legal context means sovereign or the highest. What does it mean for someone to be sovereign? And here he actually borrows language from the Roman law of family. It means being independent, independent of a foreign power, independent of someone else. Now, in Roman private law, independent meant being the head of household, patriarch. So you're the head of household, you're the eldest male agnate within the family line. Everybody else is somehow dependent or subject to you. And he uses that imagery of the Roman family to talk about what a state is. It's not territorial at all. If you're the head of household, it doesn't matter where your children or your grandchildren are located. They could be all over the world, scattered. But your sovereignty, your supremacy over them remains complete and unchanged. And it's not a geographical concept. And that actually fueled a lot of Bodin's thinking. The last thing I just want to say briefly about this, and I'll end it here, is that when one reads Grotius, it really reads like a private law treatise. And one of the reasons why is because in the opening of Book 2, he says that, a very famous sentence, where legal remedies end, that is where war begins. Yeah. And by implication, international relations. So there's a kind of legal analogy. The reason why states go to war and may have legal disputes that may require legal dispute resolution is because courts have failed them, or the court or the forum where they would get it resolved is not available to them. So when you look at the text, you have discussions about property, you have discussions about contracts, you have discussions about delicts. So it follows the pattern of Roman private law and scholastic discussions of these topics. But because the usual remedies are not available, he has to invent them. Again, it's a very elastic way of thinking about the law, but it draws and is inspired by that private law legacy.
Yeah, I mean, Grotius is very interesting in that sense too, because remember his earlier work also, De Jure Praede Commentarius and other things that he was looking at earlier in his career. He's actually a private lawyer. I mean, he's working for the East India Company, and he's litigating cases involving seizure of property and dealings over property, and trying to justify things like private war and colonization, actually, of what's now Indonesia, by virtue of these kind of principles of property relations in the law. And when there is no law, you have the right to use force, essentially, he starts to say at one point. Like if there's a basic law of respect, if there's a higher law, respect that. If there's no law, there's basically nothing to be done. You have to just go to war. So yeah, it's I think that remains consistent in his thought throughout.
Yeah, war is basically lawsuits. I mean, I think some of your, it's not politics by other means. It's lawsuits by other means.
Clausewitz on his head, kind of.
Yeah, exactly.
Yeah, right. Yeah. So in that sense, yeah, exactly. It's lawsuits by other means, but not just lawsuits. It's torts by other means. It's a kind of. Right. Yeah, I mean, it's not just any kind of lawsuit. It's a specific kind of. Oh, that's really interesting, actually. Well, alas, ruit hora, to use another Grotius term. So we've got to turn over to questions. Now, let me see if I can use the technology correctly to find the questions in the Q&A tab. We actually don't have many, so we have some time to discuss this. We have one question, and the questioner asks, why can't a sovereign be both in the position to change the laws and be bound by them at the same time, at least in theory, even though he wouldn't accept a court above him in Bodin's view? Wouldn't that be the easiest way to counter any argument that this type of sovereignty is a recipe for tyranny?
Yeah, I certainly think so. I guess, well, so earlier I mentioned that Bodin introduces a more elastic way of thinking about law. And so if you back up to his own legal theory, he's pretty consistent in saying that we're not just talking about laws that are positively promulgated by sovereigns, right? So part of what it means to be sovereign is that you can create your own law, of course. So he says a lot about civil law, but that's not the only type of law. And so when you look at his broader, more elastic and fuller picture of law, he's also talking about the relationship between sovereigns and the law of nations, the jus gentium, which is basically, I think at this point, something like the customary norms that are observed by all states. And so it's not just public international law, but also laws about, say, contracts that all sovereigns observe, pacta sunt servanda, these types of norms. Mm-hmm. But also natural law, which has actually played a very important role for Bodin. Because courts could enforce rules of natural law, and that actually is one of the important ways that Bodin tries to place sovereigns under natural law, particularly under the jurisdiction of their own courts, in certain very extreme cases that he imagines, and divine law as well. So you have all of these different categories of law. And so if the question is, how can a sovereign be bound by law and also create and enforce their own laws.
Hmm.
I think one way he tries to get around that is saying that, well, sovereigns create their own laws, of course. They can make and unmake their own laws. And that's all addressed to their own subjects. But you can't be bound by your own laws. And I think part of it is just, I think, goes back to his view that if you're bound by your own laws, you're not really sovereign in the first place. I think so here's an illustration I sometimes use for my undergraduates to explain this point. New Year's resolutions, right? So if I give myself a law, a resolution that says I shall not have ice cream after 9 p.m., I will break that. But who have I violated? Who have I harmed in doing that? It's sort of like the impossible. And this is another Roman law rule. This is why you can't owe money to yourself. This is why you can't make promises to yourself, because you can always release yourself from that. There's no harm in those sorts of cases. You can forgive yourself. But it's different when you're talking about others. So again, it relies on this relational concept of sovereignty. Now, just one final point. When you're talking about natural law, you're dealing potentially with the rules of right reason, your relation with other, not just with other states, but also with other individuals, but also God potentially plays a role in this as well. And that complicates the picture even more.
One other way I think of thinking about some of this could also be maybe, and correct me if I'm wrong, if we remember kind of the second part of Weber's definition of a state that functions, so not just a monopoly on the use of violence, but some kind of bureaucratic or systematic apparatus for the exercise of that monopoly, right? It has to be there in order for the state really to be functioning. Or what, sort of legal positivists like to talk about second order rules, right? And this idea that you have the basic rules that structure the state and the way that the state should work, but then you have all these rules about the way that power is applied. And it's not that the state has given up power, or that the monopoly holder of violence in the Weberian sense doesn't still have that monopoly. It's just that it isn't exercised haphazardly. It's done through predictable rules that are public and known, and through processes that people can find a bit more consistent, rather than just the whim of whoever's doing it. That might be a way of kind of getting around some of this.
I think that's right. I mean, one of the things I was very keen on explaining is that I don't think Bodin is kind of the ancestor to somebody like John Austin in his theory of law. There are just too many problems and too many disagreements here. And I think you're absolutely right that it's very much a rule-governed and norm-governed picture of how sovereignty is supposed to operate. So when you anticipate somebody like Hart's picture about higher-order norms or higher-order rules, the importance of a rule of recognition, something like that, I think that's really built into there. In the way that I think Bodin is thinking about why you need a sovereign to control and reshape those rules as necessary.
Okay, I think we have time for one last audience question, because there is one more there, which says, could you share your own views on the current geopolitical conflict of interests and how it affects the UN Security Council's ability to fulfill its mandate? I'm not sure exactly which conflict of interest or which mandate we're talking about here, but it says internationally recognized human rights heavily depend on the international community, but decisions are taken from a national standpoint, says the questioner. I'm not sure I know exactly which conflict they're referring to, but I guess you could take this in whichever way you would want.
I mean, there's a lot there. I mean, I guess I break it up in several ways. So I thought a little bit about this in my last book on Bodin, and I included this with the suggestion that many of these older ways of thinking about sovereignty actually originate from something that seems familiar to contemporary R2P doctrines, the responsibility to protect. I think for somebody like Bodin, for Grotius, and for many of these, at least early theorists of sovereignty, they came across the problem of justifying why do we need sovereignty? I mean, and this goes back to my earlier question. We did just fine without sovereignty in the past, but now we need to specify this type of concept. And so when they come to the question of explaining why, responsibility, protection becomes actually a big part of it. And so I think when the discussion comes up about what is the role of sovereignty in global conflict, especially in the role of institutions like the UN when their mandate is something like protection of human rights. I see the UN in some ways as a kind of continuation of what that original mandate is, of what the purposes of sovereignty are supposed to be. So I don't see them as a conflict. I think it's become, I think in some quarters, pretty standard of thinking of sovereignty and human rights and institutions that protect human rights is somehow at odds, that they're at loggerheads against each other. I don't think that's true. I think there very much is continuity. The reason why the United Nations exists, I think, and particularly the Security Council, is that it's an exercise of sovereignty, right? In some ways, I think it's a better way of exercising sovereignty than I think what the alternative might be. So I think there was actually a lot of continuity here in thinking about what the roles of sovereignty. Sovereignty exists for protection. If sovereignty exists for providing better order in the interests of the state, I'd like to think the United Nations is somehow being continuous with that general mission. So I think there is actually a more coherent narrative that I think could be written in all of this.
Couldn't there also be a negative side to this as well, though, in the sense that, if I understand where you're going correctly with this, which is that if sovereignty is construed in this kind of clientelistic frame, right, or paternalistic frame even, right, where you have this dependency relationship of the citizens on the state or the state caring for its children. Certainly this is a kind of framework that very easily was used in the past, including directly from Grotius, as a justification for imperialism, right, and for colonization, and for treating colonies as those scattered children to be cared for and tutored and protected. And in that sense, is not the United Nations at some risk of at least appearing also to be this kind of paternalistic, kind of clientelistic institution, or in other words, not very legitimate institution in the view of a lot of people, or wrong institution in the view of a lot of people?
Well, pick your favorite description, I think. And so, if you can move away from that explanation without, you could still have these institutions in place. You can still have a theory of sovereignty without it bending towards a theory of colonial patronage, colonial clientism, and I think. So I think that might be one way of avoiding it, and kind of thinking about what's a better way of explaining it. And, do you want to develop a separate political theory that starts with the theory of individual human rights, that begins with a theory of the function of states as protecting individual rights, civil rights, providing the rule of law? You could certainly do that, but I think you'd end up with something fairly similar if we're ending up in a world that still is constituted of sovereign states, if that's the basis of global political order, and you need some sort of institutions to create rules for cooperation, protection, and identification of common interests, using in a world that's still made up of sovereign states that are motivated by these concerns. It seems to me that you would end up something similar, and that you would not need to go to the extreme step of saying, let's give up on this, let's try to pick up something else, like a global state or something like that. Just don't see that happening. And I think that you already have the materials there with the theory of sovereignty that we have inherited.
Sure. No, I agree with you. I was basically playing devil's advocate on this to some extent, but I also think, this opens up a whole additional very interesting road to go down that unfortunately we don't have time for today, which would be to think about supranational sovereignties. And how those can or cannot be constructed. And the Roman Empire obviously is such a kind of sovereignty in some ways, but so would be the United Nations or the European Union or any number of other sort of constructed entities in which sovereign states come together in order to create a supranational sovereign structure. Or at least semi-sovereign structure. You could debate, does the European Union actually have sovereignty? Does the UN have sovereignty? I'm not sure, but it would be really interesting actually to pursue this further.
Excellent. Great. Well, perhaps next time then.
Yeah, I think, let me just check the time. I think for today we are pretty much out of time. I just want to see in the question tab, there is actually a follow-up question.
Okay.
So let me just pose you this one follow-up question. I'll leave you at that,
Okay.
as long as you don't need to run to another meeting or anything right
No,
away. Because I know we are kind of going over time, but to me, this is super interesting. So the follow-up question is from the original first questioner. And this question says, it is often noted that sovereignty is a modern doctrine, yet Bodin developed it partly in dealing with ancient laws, trying to determine who was sovereign in the Roman Republic and Roman Empire. Is the doctrine therefore only modern in the sense that it became directed against customary law?
Yeah, that's a great question. I do struggle in using the word modern to talk about sovereignty. And your questioner actually really, it's a great point because one of the reasons why Bodin seems to have constructed it was for historiographical purposes. And in fact, this is actually one of the theses that I pursued in some of my earlier work. I mean, I'll just back up in this and say that before Bodin wrote this text, maybe the decade beforehand, he wrote another work that was called, that really dealt with historical methodology. And so, if you're writing a history, if you're reading historical texts, what is the proper unit of analysis, right? And so it was in that work that he first came upon the concept of sovereignty. But it wasn't for political or theoretical purposes. I mean, there were it was sort of an early attempt at trying to develop those ideas. But when the question is posed, what makes a good history? Is it that you write the history of a person? So like, world historical figures, is that the right way to write a history? Do you write the history of religions? Do you write the history of, say, a tribe or a clan? No. Bodin's answer is that you have to write the history of a state that has independent sovereignty. That's the proper unit of analysis. So in answering that, he has to give some explanation for that, which we talked about today. But to address your question, I think it's interesting that one of the reasons why he developed that was to explain what's a better way to write Roman history. What's a better way to write, say, Egyptian history, or what's a better way to write the history of the ancient Hebraic peoples? And his answer is that you need to imagine them as a sovereign state. So it seems to me that at least his early theory of sovereignty, and this is true not just for Bodin, but I think for a lot of writers that were interested in historical methodology, is that they were really trying to construct the theory of state for historical scholarly purposes, right? So it is a modern concept in some ways. Right? I'm not saying that they didn't have concepts of authority at all. Of course, you'll see that throughout history. But this particular concept of sovereignty, at least Bodinian sovereignty, was originally inspired for historical academic purposes. So it's modern, yes, but for ancient purposes. He's trying to redescribe what Rome was, so it's a great question. I really appreciate that.
It also says very clearly, I think, that this is an inductive theory of sovereignty that he's building rather than a deductive one to start with, that he's actually looking at the evidence from ancient history and trying to draw up from that rather than starting with a preconceived idea of what sovereignty should be and then going through to the evidence. Yeah,
that's why he's so interesting. I just think it's just so fascinating to read.
We'll have to do another session at some point on other aspects of Bodin and also on this idea of supranational sovereignty. But it's been really great. It's great also just to have a chance to talk. Again, it's been too many years since we've had this kind of conversation. It's a lot of fun. I hope that the audience also has had fun. Most of them have stayed with us all the way through, so that's impressive. Thank you very much. Thank you everyone who's tuned in. Thank you, Dan. And if you haven't yet, for those of you watching, please do sign up and check the newsletter and other aspects on the website for the next iterations on the Ancient Geopolitics series. So thank you very, very much, and goodbye. Thanks.
Thank you.